Well, Alberta's government has invoked the notwithstanding clause for the fourth time in under 2 months. The latest legislation was passed in the early hours of this morning, and it confirms the intended use of the constitutional tool to shield 3 laws relating to the transgender community from legal challenge. The CBC's Hilary Johnstone has more for us. So what happened early today? It was 2:20 in the morning.
Very early, the pre-dawn hours, and that is when this bill passed. Alberta's premier was not in the chamber for when that happened, but this bill moved quickly in some of those final stages. The UCP were able to use their majority to limit discussion in the final 2 debate stages. The bill that has now passed, it confirms the Alberta government's intention to use that notwithstanding clause in order to shield from any sort of legal challenges 3 current laws that are affecting transgender people. And that notwithstanding clause, it allows governments essentially to override certain sections of the Charter for a period of up to 5 years. So when we're talking about those particular laws, one of them will police names and pronouns in schools. The other one would ban transgender girls from participating in amateur female sports. And then the third one, it would restrict gender-affirming healthcare for youth under the age of 16. It would essentially block doctors from being allowed to prescribe puberty blockers and hormone therapy for people who are under the age of 16. We heard from one UCP minister speaking about this, why they felt it was necessary to invoke the notwithstanding clause in order to pass this bill that then shields those 3 other laws from any sort of legal challenge. Here is a little bit of what we heard from one of those UCP ministers.
Drawing a line and protecting children from making irreversible changes at such a young age. The idea of allowing minors to medically transition before we even let them drive a car or vote is abhorrent. Mr. Speaker, in some instances, at the ages we're talking about, we don't even let our kids choose their own bedtime or their own curfew.
Now, the Canadian Medical Association, for its part, has challenged this, saying that it violates doctors' freedom of conscience. And the Alberta Medical Association has also repeatedly said that puberty blockers do not render a person infertile or sterile, and that they don't protect transgender children from more permanent changes that come with puberty. And certainly, we've heard from families of transgender children in a separate lawsuit as well, challenging some of these restrictions, saying that once this all comes into effect, that it would be devastating for their kids.
And of course, we were just mentioning how this is the 4th time that the Alberta government has used the notwithstanding clause just in the past 2 months. We know that the opposition has been expressing some concerns about that. Let's walk through some of those concerns that we've heard so far and what it all means.
So they have said, the opposition has said that the notwithstanding clause is something that is supposed to be used in exceptional circumstances. And they do not feel that using it to shield those 3 laws related to transgender people in the province of Alberta, to shield it from legal challenge, that is the right way to go about doing this. You heard some opposition members in the early hour of this morning saying that if the UCP felt that this was important to bring forward, then why are they using the notwithstanding clause in order to try to shield it? I do want to bring you a little bit of what we heard from one Alberta opposition member, Janice Irwin. Here is what they said.
We fought hard against a UCP government that invoked the notwithstanding clause an unprecedented number of times, and this government was taunting us, saying that we would have regrets. Let me tell you, this is a UCP government that's going to have big regrets about the decisions they made this past session.
And now, like I said earlier, just finally here, Alberta's Premier Danielle Smith was not in the chamber for that early this morning, but just yesterday, she had said that they believe that children need to be of an age where they can understand if they're going to be making decisions that affect their own ability to have children one day, and they need to be making those decisions, she says, as a mature minor.
Okay, Hilary, thank you for this.
Thank you.
That is the CBC's Hilary Johnstone reporting. And we do want to stay on this story and talk about the potential implications on Alberta's reliance on the notwithstanding clause. So for more, we've reached Kerry Bowman. He's the professor of bioethics at the University of Toronto, and he joins us now from Toronto. Thank you so much for joining us today.
Happy to do so, Arthi.
Well, Kerry, we've been talking about how the province has used this clause 4 times in less than 2 months. So what is it specifically, and why is its use so controversial?
Well, I'm a bioethicist, so I'm going to obviously be looking at this from an ethical point of view. And when we look at the Canadian Charter of Rights and Freedom, the argument would be that they're forwarding, as these are elected, governments that are doing what they believe is right. But the actual ethical platform that we live by under the Charter is to protect the rights of minority people, that fundamental rights need to be secured and protected, including from the government and from government oversight. So, that is definitely one of the main elements with that. And then also this would only be used in really exceptional circumstances for a short period of time where there's no alternatives. So, the way it's being framed is we have to do this to protect children. But, let's look to fact and evidence. Since when can't we count on the Canadian Medical Association? So, there's that as well, as we're kind of walking away from fact and evidence. We're not respecting the rights of minority. And, a really, really big one, Arthi, is the erosion of trust of our politicians and our charter in general, to just walk away from this and just say, no, we're using it again, we're using it again. It really erodes the really democratic platform that we're working from. I mean, we were I teach ethics at the University of Toronto, and one of my students said, well, if that's our platform, how can we just walk away from it so many times? So, and also, that this would be used more as a political tool than something that's really protecting someone's fundamental rights. So I really do see a lot, independent of the issues that are going on in Alberta. I'm just focusing here on the use of, and I see lots of ethical problems with this.
Because you did touch on the Canadian Medical Association, I want to ask you a little bit more about that before we talk a little more broadly about previous and past use of the notwithstanding clause and this most recent one by the province of Alberta. We know that we've been talking about how the Canadian Medical Association has challenged this law in court, saying it violates a doctor's right to freedom of conscience because it, of course, as part of the law, it prohibits restricts gender-affirming healthcare for youth under 16. So what do you make of freedom of conscience and this case that was brought forward by the Canadian Medical Association?
I think it has a lot of validity, and doctors have a lot of obligation to the protection and well-being of their patients. And when a physician in good conscience feels that they're being blocked from doing this, I think we really, really have to listen, especially if fact and evidence don't line up with if medical fact and evidence don't line up with what is being said. I really think we have to listen to that. And on top of all that, it's so divisive. We don't need this. Look at the world we're living in. We don't need to be pulled apart in this way. So there's really a lot to worry about here. And it also, it kind of derails the judicial process because these things don't end up in a court. They're quickly, pulled up left, right, and center. So I think it's a threat to all of us as Canadians, and it's very divisive. And again, and I purposely repeat myself here, it really erodes trust in our democratic system and the very values and ethics we live by.
I also do want to bring the voice of what we've heard from representatives from the government. For example, the Environment Minister had said in Alberta that this is not about denying kids care, that we have a duty to ensure that care heals, that it stabilizes and protects, that it doesn't endanger. So that's, part of what we've been hearing in terms of the rationale for using the notwithstanding clause in this case. Has this use of it differed from past use of it? Because we have seen it used in the past too, including in Ontario.
Yeah, we have. I see this one as different because, it's a cluster. It's 4 in a row. If I've got this right, this is the first time that, we've had this much intensity. Quebec has come up with notwithstanding. But, the situation with Quebec is very, very complex. And so, yeah, I mean, this has come up. And again, I purposely go back to the fact that, they're saying we are doing this for the safety and well-being of children. Let's look to fact and evidence and, infertility and these types of, what does fact and evidence tell us? And I'm not an expert on those issues at all, but I, like a lot of healthcare professionals, I look to people within my field that know more about this than I do. And I think that's how we have to move forward on these issues.
Carrie, I want to thank you for this conversation. I appreciate your time.
Happy to do so.
That was Carrie Bowman, professor of bioethics at the University of Toronto.